Hello, my name is Allison Sills, and I work at the Central Carolina Community College as an instructional librarian. As librarians, we cultivate a lot of information and inhabit a lot of societal trust for doing so. I feel it is our duty to be the very best stewards of that information as we can be. So let's talk about the ethical tightrope we walk between balancing library values today against specifically North Carolina's new Parents' Bill of Rights and the patron privacy challenges it engenders. When it comes to patron privacy, we each know our own struggles, whether you work at a K-12 school library, a public library, a university, or a community college library. Community colleges are experiencing a unique crisis because we often host high school-aged minors in early colleges, as well as our adult students. The Parents' Bill of Rights law passed in 2023. Shortly afterwards, North Carolina community colleges were pressured to compulsorily turn on patron checkout history tracking for the first time. Ultimately, however, the choice to leave on patron tracking or to turn it off was left up to each institution. Today, I'd like to talk to you about the choices. FERPA, the Family Educational Rights and Privacy Act, was passed in the 70s, and that law allowed parents the right to view their child's educational records. That law predated computers, then the digital age happened, and records keeping became not only easier, but allowed for a vast, almost limitless amount of storage for data. As that data was migrated online, storage became less and less secure. As hackers and even our own government became interested in this data, our professional organization had to come up with new ways to protect our patrons. The American Library Association recommended data minimization in 2002. So today let's talk about the history of privacy in libraries. What does our professional organization say about privacy? And what does the law say? Has anyone ever seen the movie Seven? It came out in 1995 with Brad Pitt and Morgan Freeman. It's a horror film and it's graphic, so it's not for the faint of heart. But you can always watch this clip on YouTube, which is in my references as well. There's a scene in the middle of the film where Morgan Freeman uses a contact at the FBI to get circulation records for certain books. You can see the closed caption here on the screen. And spoiler alert, this is how they catch the killer. When I first saw this movie, I cried foul. I didn't really think that this scenario was possible. It was not only gross government overreach, but even Brad Pitt's character says, "How is this legal?" I was convinced it was a fictional plot device that was made up for the movie to move the story along. It could never happen. No library would allow it. Boy, was I wrong. Not only did it happen, it had a name and it went on for decades before it was finally revealed to the public. And it continues to this day. So let's talk about the history of privacy in libraries and the government. And I'm going to spend some time here because I want you to get a real feel for what our purpose was, what it has become, and what real threats we're facing. So let's go all the way back to 1906. In this first case I could find of government surveilling a library. But it wasn't our government that was doing the surveilling, it was the Russians. Because at the time, Russia was a monarchy and an ally. And in an article from the New York Times, the Russian Secret Service surveilled, and I quote, all libraries in the city of New York. They were looking for readers of books on anarchy and also just any books in German. In 1906, there were international agreements on information sharing for the policing of anarchists. Due to the assassinations of world leaders, Tsar Alexander II in 1881 and President William McKinley in 1901 by anarchists. In 1918, we are at war, and the USA passes the Sedition Act, making it illegal to speak, write, print, or publish anything critical of the U.S. government. Even though this was repealed in 2020, this is really the start of a time where libraries are used not only to censor materials the government doesn't like, but also to target the readers of those books. And it is not a small segment of the population. First, it was books on anarchy and German language books. Then after the Russian monarchy falls to the Bolsheviks, it becomes Russian language books and books on communism and Marxism. And then the Jim Crow laws are adopted. This quickly leads to bans on books promoting not only African American stories, but just also liberal or left leaning causes. And librarians don't like this misuse of their profession. After 20 years of discussion, librarianship officially adopted the concepts not only of equality, but also confidentiality as ethical obligations, similar to other professions like law and medicine. As World War II begins in 1939, and in response to increasing propaganda and increasing censorship, the ALA creates the Library Bill of Rights and the Code of Ethics to make their positions official. In 1947, the war ends. The Soviet-centered Red Scare begins. Our wartime alliance with the Soviet Union collapses into an ideological and political rivalry. All those Russian employees that were previously allies are quickly spies. President Truman orders loyalty checks of all federal employees, and the newly formed House Un-American Activities Committee accuses even the Library of Congress of harboring aliens and foreign-minded Americans. This begins a very charged period of suspicion, innuendo, accusation, retribution, now known as McCarthyism, named after Senator John McCarthy, who was a virulent anti-communist. Librarians caught up in this controversy had both their funding and their employment threatened after any pushback. Pro-Soviet books were purged, and soon other materials viewed as anti-American followed. Librarians, often federal employees, had to sign loyalty oaths. Those who didn't sign faced scorn and often lost their jobs. When half the staff of the LA County Library System left rather than sign loyalty oaths, staff member Julia Learned Steiner takes her case to court. She is upset that her neighbors are being asked about her reading habits. And that case becomes a part of the first loyalty oath challenge decided by the U.S. Supreme Court, which she lost, incidentally, and loyalty oaths do continue. But in response to these events, the ALA revised the Bill of Rights and published a resolution on loyalty programs that says librarians are both free from persecution by surveillance and should provide those same protections to their patrons. Peacetime brought exactly that, and much controversy around libraries' privacy and censorship, it died down until we entered the Vietnam War. In 1970, the government again started surveilling libraries to find bomb-making radicals and dissidents. Called the IRS inquiries, it was actually the Alcohol, Tobacco, and Firearms Unit, then also housed under the Treasury Department, that made the inquiries at 3 libraries across the nation. Those inquiries made the news in July of '70. North Carolina Senator Sam Ervin, chairman of the Senate Subcommittee on Constitutional Rights, requested an explanation from the Secretary of the Treasury. The Secretary responded with some details, but finally said that their policy would continue to request access to specific library records in justifiable situations. In 1971, in response to this intrusion, the ALA publishes a new policy on the confidentiality of records, reiterating that we protect each library user's right to privacy and confidentiality, except when presented with a lawful subpoena, which those inquiries did not possess. Unbeknownst to almost everyone except a few libraries directly involved, the FBI has begun surveillance of libraries in a new program called the Library Awareness Program. And there's an entire book written about this, if you're interested, called Surveillance in the Stacks by Herbert Forrestal. It's a fascinating book. If you want to know more about the situation, it's remarkably similar to the incidents of the Patriot Act. There really does seem to be a 15 to 20-year cycle on privacy concerns. I attribute this phenomenon to the length of human memory on the subject. History just keeps repeating itself. By 1975, rumors are starting to circulate that libraries again are being targeted by the FBI. The ALA published a statement on the professional ethics. It reaffirms again that librarians must protect the essential confidential relationship which exists between the library user and the library. In 1988, eventually, Congress schedules hearings on the FBI's Library Awareness Program. You can watch these proceedings on C-SPAN. You can email me for the link if you're interested. It's just fascinating testimony. It's the Cold War, and the FBI was concerned that foreign nationals were piecing together non-classified, commercially available information and somehow gaining intelligence that way. This was never proven to be true throughout all of the FBI's diligence. The author of the book, Surveillance in the Stacks, Herbert Forrestal, he is one of the people testifying. And while the FBI announced at those hearings that the program had ended, FOIA, or the Freedom of Information Act, requests eventually revealed that they did not stop investigating even through 1989. The FOIA also revealed that they had conducted over 100 background checks, searches on librarians or their associates who had criticized the program. Even after the hearings, at no time was any order delivered by Congress to the FBI to cease or desist. So everyone talked about how bad it was, but no one did anything to stop it. 9/11 happens in 2001, and the Patriot Act is passed just 5 short weeks later. In the Act, Section 215 greatly expanded the Foreign Intelligence Surveillance Act, or FISA, which allowed for the seizure of any tangible thing under reasonable grounds, not requiring a warrant. And if approached, you were not allowed to discuss that interaction. There was a gag order attached. The FBI is granted the ability to search 3 levels down in data, and that means Kevin Bacon degrees of separation. So if you know someone who knows someone who might know a foreign contact, you could be thoroughly investigated and secretly. And within a year, just 1 year, the San Francisco Chronicle reports libraries are being contacted for their data. The University of Illinois sent a questionnaire to 1,000 libraries nationwide. 85 report that they had been asked by federal or local law enforcement for information about patrons. That same year, the ALA amends its advice to the nation's libraries and recommends avoiding creating unnecessary records, aka start employing digital data minimization. Ann Turner, president of California's Library Association, says, "They can't find what we don't have." In 2005, 4 librarians with the backing of the ACLU appealed to the Second Circuit Court of Appeals to have gag orders removed from themselves so they can talk about their experiences confronting the FBI. This freedom was granted, and again, the cat was out of the bag that the government was spying on its citizens. And they did not fulfill those requests without a subpoena. They were asked to, but they didn't. In 2013, what we wouldn't know until a decade after 2005 was just how deep the surveillance had become. In 2013, Edward Snowden whistleblows that the NSA is tracking everyone's emails, texts, and phone conversations globally in unprecedentedly broad searches. I strongly recommend that you, if you haven't already, please watch Citizen4, the Academy Award-winning documentary of Edward Snowden. There's also Oliver Stone's movie. Or please read any book that you can find on him. If I cannot convince you the government is coming for your records, maybe this material can. In 2019, in response to these revelations, the ALA finally adds Article 7 to the Bill of Rights. We'll go over that text in just a minute. But a year later, in 2020, the U.S. Foreign Intelligence Surveillance Court revealed that the FBI misused its controversial surveillance powers more than 278,000 times to conduct warrantless searches on protesters on both sides of the political spectrum, including Black Lives Matter protesters and January 6th protesters. And most of these are U.S. citizens. So now, power once given is seldom returned. We are facing that right now. The Patriot Act was supposed to sundown after 4 years in 2005, but it was renewed again and again and again and again last December and again last month in April for 2 more years. And it is because we may never get that power back that we librarians must think again how best to protect our patrons. Now we have a new law to interpret, the Parents' Bill of Rights. So what does our professional organization say? Privacy is a key component of our very core values. The ALA devotes no less than 9 heavily referenced pages to the subject. So what do they say? The Bill of Rights, the Library Bill of Rights has 7 articles. Number 7 says, all people, regardless of origin, age, background, or views, possess a right to privacy and confidentiality in their library use. Libraries should advocate for, educate about, and protect people's privacy, safeguarding all library use data, including personally identifiable information. Our professional code of ethics, third of 9 codes, says we should protect each library user's right to privacy and confidentiality with respect to information sought or received, or resources consulted, borrowed, acquired, or transmitted. Our freedom to read statement covers a lot of bases, and I highly recommend a reread if it's been a while. My favorite line says, suppression is never more dangerous than in a time of social tension. Freedom has given the United States the elasticity to endure strain. Every silencing of heresy, every enforcement of an orthodoxy diminishes the toughness and resilience of our society and leaves it less able to deal with controversy and difference. We need a tough and resilient society to face the problems ahead. What does the ALA recommend for our vendors? They too have to adhere to our values and the federal laws around FERPA and COPPA. Again, data minimization is mentioned, as is that users should have the choice to opt into any data collection that occurs. That means if you change your procedures, say turn on patron history tracking suddenly, then you are duty bound ethically to inform your patrons so they can decide to voluntarily opt in or out if they so desire. You can see here some of the other vendor requirements. We should be at the very least as attentive to our patrons as we require our vendors to be. What exactly does the law say? North Carolina law has a privacy law in the books, as do 48 of the other states. North Carolina General Statutes, Chapter 125, Article 3 states that a library shall not disclose any library record that identifies a person as having requested or obtained specific material, information, or services, or as otherwise having even used the library except upon written request of the user or pursuant to subpoena, court order, or where otherwise required by law. It's very important that you train all of your workers about the specifics of the law, because this is what adults are going to reference if you give out any of their information without cause, and it leads to repercussions. And if anyone has worked in a public library for any length of time, I'm sure they have at least one story to tell of the cops coming in and asking for information. I have several. Staff training is important as our desk staff deal with these requests from both law and parents, and you may not be there when they do. It could happen during lightly staffed evening hours. So finally, we're at this new law, the Parents' Bill of Rights. What exactly does it say? Under a section called the Public School Unit Requirements, it says that parents have the right to review all available records of materials their child has borrowed from a school library. Let's break that down a little deeper. What is a public school unit? Obviously, public schools fall into that category, but what about community colleges? The bill has a few definitions and defines the state as the state, any political subdivision, or public school unit. The use of the word "or" implies political subdivisions and public school units are different entities. So as far as community colleges are concerned, they do more align with the definition of a political subdivision than a public school unit. Also, NC General Statute 115D on community colleges states that the major purpose of a community college shall be the offering of vocational and technical education and training for students who are high school graduates or beyond the age limit of the public school system. So a community college, and thus its library's documented primary purpose is to serve adult students seeking vocational accreditation. Now let's define all available. Prior to the Parents' Bill of Rights, FERPA law, which I mentioned at the beginning, already existed, and FERPA is a federal law that already gave parents the right to review their child's educational records. So what were you doing prior to the Parents' Bill of Rights? This is where I found processes differ. I've interviewed school librarians who always had history turned on and some who always had it turned off. Community colleges in North Carolina, to my knowledge, had tracking turned off, and we were in compliance with FERPA then. So if the language of this new law is similar to FERPA, why should we be behaving any differently? All available is not defined in the new law, so we can assume it means all available according to our professional ethics. And our professional ethics recognize that children have the same right to privacy as adults, and libraries should collect the minimum amount of personal information required to provide service. That is from ALA's guideline for K through 12 schools. We comply by providing current patron circulation information to a parent or by subpoena by law. And parents can ask every week if they choose, but we do not keep historical records to protect our patrons' privacy. The new law does not insist nor require that we change the way we do business. It also does not insist or require that we start creating something new that we did not before. So what does federal law say? And I hate to be that guy, but I guess I'm going to be. That constantly goes back to the Constitution. Federal laws and the U.S. Constitution also address the right to privacy, if indirectly, through subsequent court cases. The First Amendment implicitly safeguards the right to privacy in the form of freedom of thought and intellect, as articulated by Supreme Court Justice Louis Brandeis in his famous dissent in Olmstead versus the United States. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. This is right off of the ALA's website. And in Griswold v. Connecticut, William Justice O'Donnell placed the right to privacy in a penumbra cast by several constitutional amendments, including the First, Third, Fourth, Fifth, and Ninth Amendments. So even though there's no constitutional amendment specific to privacy, its importance is implicit in several amendments. So again, if you have any doubts about the responsibility of us on this subject, please refer to ALA's pages on privacy, especially if you need talking points to address others with concerns. So what about future laws? I've heard people argue, don't we need this now because future laws are coming, right? In a discussion about this new law, I've heard people who expressed fear about what the legislature might do in future laws. First, if we are afraid, our patrons are afraid. The fear cycle needs to end with us. We stop the fear cycle for our patrons. And second, no one will protect us later if we don't stand up for ourselves now. As for other laws, they did try to introduce a much more stringent bill in 2023 called the Children's Omnibus Bill, Senate Bill 90. It added restrictions onto public libraries who would have had to move materials into age-restricted rooms, and that parents must give written permission for minors to check out certain books. But parents kind of already do have that privilege because a parent is financially responsible for the child's account. Children under 18 can't enter into legal contracts. I know there are instances of teens getting library cards at 16, and that is fine if you are not going to pursue legal action against them, like send them to a collection agency or to recoup your losses. But most libraries I know of don't use a collection agency, and they just leave any charges on the account in the hopes that the patron will return and settle up with them later. In most cases I know about, a parent signs up their minor age child, and if the child loses a book, then the parent is legally responsible. So parents always already had access to know what their child had checked out because they have to find those books and bring them back. But even this, the NC legislature couldn't get the votes on this kind of bill. The House of Representatives Speaker Tim Moore said, "I don't know that the votes were there for it. There was some pushback within the caucus about some provisions concerning libraries or books." So we do have the support of our legislature on all sides. Even if we didn't, in states where libraries don't have such support, this happened in Arkansas. A similar bill to this omnibus bill in North Carolina passed in Arkansas. And not only that, did it add public libraries, it also added bookstores to the list of restrictions. 18 plaintiffs have sued the state, and the federal judge enjoined parts of the law that he felt were unconstitutional. They were unconstitutional against the librarians and the booksellers. That federal lawsuit goes to court in October of this year. So we shall soon see how the federal law lands on this topic very soon. Here's some things to consider if you have patron checkout history tracking turned on. This kind of tracking is akin to book banning because it will lead patrons to self-censor to avoid future potential persecution. How are you going to inform your current patrons about the tracking? And how are you going to get the consent of future patrons? Are you going to put it in a form? How are you going to inform them? Who is going to handle requests from parents and law? Is it going to be the director only? All staff should be trained on best practices because many of us employ student workers. Student workers should be trained that they are not to disclose information that they have access to. Student workers will have access to the checkout history of other students, but also their instructors, their deans, and even the college president as well. So please be mindful of that. Are you regularly purging patron accounts? Records only need to be held for 3 years according to the North Carolina Records Retention Schedule. So please consider purging old records more regularly. And turn off patron checkout history at 18. If you are keeping patron checkout history for minors, you should have a plan in place to turn it off when they reach 18. Because those records may be open to FOIA requests at worst. At best, they are available to law by subpoena. Remember that this new law is only for minor age students. Adults have state law that protects them. And create new policies and procedures to cover all these potential possibilities, not just to protect your patrons, but also to protect you. If you have turned on patron checkout history, you should be thinking about this now. And what is the worst thing that could happen if you don't turn on patron checkout history? The State Board of Education attorney Allison Schaefer said in an interview that parents can complain to the school board and the board can agree there was a violation, but they can't do anything. The state board cannot order a district to do anything specific. It's all up to your institution, and I hope that you are supported there. Our college has the rare benefit of having our own lawyer, and this is not legal advice. Repeat, not legal advice, because I am not a lawyer and you are not a client of this lawyer, but our lawyer made this determination based on the NC State law in the books, the wording of the Parents' Bill of Rights, and after hearing the arguments the system office and their lawyer put forward. He determined that arguments about the law not applying to community colleges was more compelling than arguments implying the law did apply to the college. He also argued that the potential damage for enacting new procedures where the Parents' Bill of Rights does apply to the colleges is not reversible and likely to result in higher monetary damages than the opposite. What that means is if we are not in compliance with the school board, they can disapprove of our stance and ask us to comply as we are able, which it would never come to that because we can and we would supply current checkout history. But if we were to disclose a record of an adult patron or a child patron and they sue, That can lead to real monetary damages. If an adult patron has his records acquired without subpoena by law enforcement, and then those records are used against him in any way, like the court of law says against his character, that library that supplies those records could be liable under North Carolina law. And three, current procedures, i.e. procedures before turning on patron checkout history, did not in any way diminishes the college's ability to respond to the Parents' Bill of Rights. I'll explain. Not only can we provide current checkout history, but did you know that Circe Dynix Workflows and Mobius's Evergreen can get the checkout history of your patrons, whether patron checkout history is turned on or not? They can. Ask your vendor. So that fact alone makes our keeping patron checkout history moot. If a parent were to become upset about wanting to see a full list of what their child has historically checked out, we can ask our vendor to get that information. And they can provide it because they have reports that they can cross-reference to build that list. And it's hard, but it should be hard because this occurrence is so rare. I doubt any community college will ever face that parent who wants a complete list of every book their child has ever checked out, because parents realize, and many are told or they read it in the brochure, that when their child starts an early college on a community college campus, that their child will be attending an adult-focused institution, and their child will have to abide by the rules of that institution. Minor age students going to an early college, they're striving to grow into a strong, resilient, and tough adult citizen. And adult citizens are the community college's primary patron. So what are the consequences of a breach in privacy? They're bad, and not always perpetrated by unlawful actors like cops or the FBI. Many breaches are unlawful. No less than 10 counties have been cyber attacked in the last 5 years. Bladen, Chatham, Edgecombe, Greene, Halifax, Jones, Nash, Orange, Pamlico, and Scotland counties, as well as Durham's NC Central, University, and even North Carolina-based book vendor Baker and Taylor, have all experienced cyber attacks since 2019. Why should we voluntarily proffer up extra information? Doing that erodes patron trust in the library. It compromises the library's reputation. It fails to comply with data protection regulations that can have legal consequences. It has a chilling effect on library use and leads to patrons self-censoring, and that narrows an individual's right to freedom of speech, the First Amendment, and freedom of expression. It breaks our Bill of Rights, it breaks our Code of Ethics, and it breaks the law, both state and federal. Can we even call ourselves a safe space anymore if we are quietly harvesting circulation information on our patrons? Protecting patron checkout history is one of the 7 most important rights libraries promise their patrons in the Library Bill of Rights. When we honor that agreement, we preserve trust in our institution, we encourage reading and learning, we protect our patrons from discrimination, we follow the majority of laws up to and including the federal level, and we support all cultures and promote intellectual diversity. It is our duty to protect our patrons as zealously as we are able. We stop the fear cycle. Even with laws like the Parents' Bill of Rights, we have choices. I implore you to stand up for your patrons' privacy and resist any pressure to keep patron checkout history tracking turned on by default. Thank you for coming. And again, I'm Allison Sills, and this is my contact information. And here are my references for the discussion today. If you'd like any more information about this, please feel free to contact me. Thank you.